Yo, what's up? So today we got an update on, at least a little update on the California lawsuit issue, specifically with the EEOC and the DFEH. So I have a Kotaku article I'll go into, but basically to run it down quickly is the DFEH thought that the EEOC settlement created some wiggle room for Activision Blizzard to remove some evidence that they wanted to use in their own lawsuit. So they have created a motion called an ex parte to stop this from happening. So let's go over the article here. We'll go over what's important because Kotaku doesn't seem to know what to put in that's important. Okay, so California steps in to prevent Activision Blizzard destroying sexual harassment evidence. The Department of Fair Employment and Housing is attempting to protect vital evidence by intervening in the recent EEOC settlement. So this is the settlement that basically was the $18 million one that said that basically we don't want to cause any undue harm to anybody, so we just want to make sure that the company stops these bad practices and the harmed employees get the compensation that they deserve. And the DFEH said, no, hold on, you can't destroy the shit we're using to investigate. So yesterday, the California Department of Fair Employment and Housing, the DFEH, filed a motion to intervene in the potential settlement between the U.S. Equal Employment Opportunity Commission, EEOC, and Activision Blizzard. The motion argues that the DFEH's own trial against Activision Blizzard will be irreparably damaged by the conditions of said settlement. The settlement includes a clause which requests that Activision Blizzard be able to remove any allegations of sexual harassment from personnel files of settlement claimants, effectively destroying evidence that is essential to the DFEH's own trial. So basically, anybody that settles under the EEOC gives Activision Blizzard the right to delete those sexual harassment allegations from their personnel file. Basically, anything that they reported to HR or their manager, or anything that they basically reported at all internally. So that seems to be a problem. I don't know why you would allow that as a provision. I feel like that should probably be marked on their record permanently forever. But I don't know. I guess that's something that the EEOC decided was allowed to happen. And of course, the DFEH is like, we need those markings of sexual harassment and the proof that the correct process was done by the employees who are harassed. You can't just delete them when we need those documents, right? So that's the problem that the DFEH is having here, is that they're like, whoa, you can't just remove stuff that we're using for our investigation. And also, this is already after Activision Blizzard had already been, ousted, or I don't know if ousted is the right word, but basically they had been shredding evidence, or the DFEH had claimed that they were shredding evidence. And so the DFEH is already like on their toes for this stuff. And it's like, now they have a right to do this. And it's creating a lot of, you know, scared people, I think, within the DFEH. The DFEH met with both Activision Blizzard and the EEOC on the 5th of October to inform both parties of its plan to intervene. Normally, it would have to wait 7 days before filing its intervention. Instead, due to the grave harm the DFEH sees in a potential settlement, it has filed the motion ex parte, which allows it to be filed instantly if the court finds it reasonable. The DFEH justifies this ex parte request by citing the settlement clause that would allow Activision Blizzard to scrub the sexual harassment allegations. So basically, if this happens, then the only part of the settlement that gets affected is that part that says that they can remove those allegations from the files. Everything else within the settlement stays the same, but not that part. And I don't know if after that Activision Blizzard is allowed to say, oh, I don't agree to the settlement anymore, or like how that works, but I imagine that they are. So we'll see what Activision Blizzard does if this is granted, and how much damage has already been done since the settlement has taken place, right? Like, have they already deleted like most of or all of the things in question? So then they're like, oh, it's okay, we can add that thing back in now because they've already deleted a lot of it. That's a valid thing that I don't really know the answer to. I hope, this is my hope, that there is somebody within Activision Blizzard's HR, or somebody who's in charge of this or is part of this, who's storing this somewhere so that there is actual justice. I know this is like wishful thinking, but I hope that somebody there has the moral compass to say, like, I'm going to store some of this just in case the DFEH comes asking again. because we really do deserve to have these employees represented in a fair way. This would not be the first time Activision, yeah, so we already talked about that. Kotaku reached out to the DFEH and Activision Blizzard for comment and received the following from Activision Blizzard. We are committed to making Activision Blizzard the most welcoming, inclusive, and safe workplace possible. I don't think that's true. I don't think that's true for many reasons. So here's one. The only thing a company is ever really concerned about is profit. So they might say we are committed to making Activision Blizzard the most welcoming, inclusive, and safe workplace possible. If that were true, then they wouldn't have even wanted this provision in the EEOC settlement, right? They would have said, no, we think that these people need to be fairly represented, right? They would have done something against their own interest if this is truly what Activision Blizzard cared about. But it's not. They care about profit. They care about damage mitigation because they're a company. That's what companies do, right? So this is just meaningless. Our agreement with the EEOC reflects our commitment, I don't think it does, to significant improvements in transparency. Again, it's not very significant because as I went over in the video going over this EEOC settlement, $18 million is pretty much nothing to Activision Blizzard. That amount means almost nothing to this company. As well as making immediate compensation available to eligible employees who choose to participate. Right, and that compensation is nowhere near adequate, okay? So I hope that not many employees or none have signed up for this EEOC settlement yet, because if they have, then that gave Activision Blizzard the right to scrub their record, which is clearly a problem here. Activision Blizzard is ensuring a workplace free from discrimination, harassment, and unequal treatment of any kind. They are not ensuring that. Because if they were, again, they would be more forthcoming and open about these kinds of things with the DFEH. I think that they are intentionally trying to hide things, and I don't think that's too much of a stretch, as any person or company would in a situation where they're being sued. There aren't many people who would just come forward and be like, yeah, I did it. Here's all the evidence. Most people are going to try to protect themselves as much as they can, especially companies. So that's pretty much where we're at. The order to alter records is included as part of the settlement and reads as follows. Within 30 days of the date that the EEOC notifies Activision Blizzard of the names on the distribution list, Activision Blizzard agrees to A. remove from the personal file of each eligible claimant any references to the allegations related to sexual harassment, pregnancy discrimination, and or related retaliation except to the extent that the defendants must keep records of the allegations or any eligible claimants involved in this charge in order to effectuate this decree, in which case such records must be maintained separately from eligible claimants' personnel files. Now, I think this is clearly a problem. I don't even know why this is included. Maybe somebody can describe in the comments if they're a lawyer or they have a more legal understanding of this, why this would even be included, because this just seems like such a, like, I know that the EEOC cares about fixing the problems, but I don't think removing things from people's personnel file does anything to help anybody. I think it only helps the company against other legal action that should be rectified. The DFEH also takes umbrage with the clause in the settlement which allows Activision Blizzard to reinvest non-distributed settlement funds back into its own programs. Yeah, this is something else that I talked about. I don't need to read this whole thing. Basically, they can, any funds that aren't claimed by any person, they can either put into a charity for women and diversity inclusion things, for like that kind of charity, or they can reinvest into their own company towards inclusion and diversity stuff. So things that they would have to do anyway, they're basically, now this is part of that. So they were going to have to pay for this stuff anyway. So it's not really that much of a loss for Activision Blizzard if they get to invest a lot of it back into their own company. While the EEOC has final say over how these excess funds will be allocated, that any of it could return to Activision Blizzard has the DFEH uncomfortable per its motion. In addition to qualms regarding the status of its own case, the DFEH cites multiple procedural failures in the settlement. In addition to EEOC's failure to comply with the notice requirements to the court about pending DFEH action, EEOC and defendants also failed to provide complete information in the proposed consent decree now lodged with the court. The proposed decree, for example, lacks a proposed notice claim form and release. It also provides no notice of DFEH's pending action, but seeks court approval of the procedure whereby EEOC and defendants arrange for outside counsel to assist with obtaining releases of state claims to which EEOC is not party and the EEOC lacks standing to prosecute under law. Basically, the EEOC's settlement is allowing for Activision Blizzard to do things that are outside of its purview, especially when it already has lawsuits against the company. The EEOC and Activision Blizzard were required to inform the courts of the existing trial between the DFEH and Activision Blizzard and failed to do so. Normally, the EEOC would have to wait for the pending action to finish before starting their own legal action. This is especially problematic given that both trials center on similar evidence and claims. Exactly. So if the EEOC is using evidence that's also required by the DFEH to use, and the EEOC allows Activision Blizzard to remove that evidence, then the DFEH's settlement or the DFEH's lawsuit is now hindered. No information about defendants' potential liability, the maximum damages recoverable in successful litigation, or the allocation of distribution of monetary relief is included in the proposed decree. Unclaimed settlement funds also revert back to defendants, and the decree proposes destruction or tampering of evidence necessary to the DFEH's case. Finally, EEOC and the defendants did not request a fairness hearing, nor explain why the settlement is fair, adequate, and reasonable. Furthermore, the EEOC and Activision Blizzard did not request a fairness hearing, which opens the door for the DFEH's procedural and justifiability complaints. Specifics include the order to dispose of and tamper with evidence, which is obviously a problem, the fact that unused funds are funneled back into Activision Blizzard, the funds are only to be used for diversity and inclusion efforts and are distributed by the EEOC. This attempted intervention marks the second time in recent memory that, okay, yeah, we don't care about that part. So pretty much, the DFEH is like, hang on, the EEOC has done things that are not good for our case against Activision Blizzard. We want those parts of their settlement removed. Everything else can be the same. But we want to be able to prosecute the company that is operating out of our state to the full extent that we originally intended before the EEOC stepped in with their own settlement. And to me, that seems reasonable. I honestly hope that Activision Blizzard hasn't destroyed any extra evidence. I hope that the EEOC can get the justice for these people that they deserve. On top of the EEOC justice, I want the DFEH and the EEOC together going at this company, right? Like, I want every possible avenue for the recompensation of these harmed employees to be done by the law, to the full extent of the law, you might say. But let me know what you think down in the comments. Do you think that the DFEH lawsuit can still go even if this EEOC settlement is unaltered, or do you think that it's required to alter the EEOC settlement for the DFEH's lawsuit to go through properly? Let me know what you think down in the comments, but if you enjoyed the video, please like and subscribe to the channel. But yeah, that's it. Thank you so much for watching. Peace.